rise. Oyez, oyez, oyez. The Circuit Court of Cole County is now in session. The Honorable Patricia Breckenridge is now presiding.
You may be seated. We have been through the process of selecting the jury, and the bailiff has seated the jury, which is now ready to be sworn. Mr. Bowman, are you ready to proceed?
State of Missouri is ready to proceed, Your Honor.
Okay. Mr. Slusher?
Defense is ready to proceed, Your Honor.
If the jury would please stand and raise your right hand to be sworn. Do you swear that you will faithfully execute your duties as a juror by deciding this case based upon the evidence and the law given to you by the court? You may be seated. The following instructions of law are for your guidance in this case. These instructions, along with other instructions in writing, read to you at the close of all the evidence, will be handed to you at that time to take to your jury room. Instruction number 1. Today's trial is a criminal case. The state of Missouri has charged that the defendant, Thomas Theodore Crittenden, has committed the offense of murder. The defendant has pleaded not guilty to the charge. Thus, there are issues of fact that must be decided by a jury, subject to instructions concerning the law that the court will give to the jury. The jury is obligated to follow those instructions. However, no statement, ruling, or remark that I may make during the trial is intended to indicate my opinion of what the facts are. It is your duty to determine the facts and to determine them only from the evidence and the reasonable inferences to be drawn from the evidence. Your decision must be based only upon the evidence presented to you in the proceedings in this courtroom, and you may not conduct your own research or investigation into any of the issues in this case. In your determination of the facts, you alone must decide upon the believability of the witnesses and the weight and value of the evidence. In determining the believability of a witness and the weight to be given to the testimony of the witness, you may take into consideration the witness's manner while testifying, the ability and opportunity of the witness to observe and remember any matter about which testimony is given, any interest, bias, or prejudice the witness may have, the reasonableness of the witness's testimony considered in the light of all the evidence in the case, and any other matter that has a tendency in reason to prove or disprove the truthfulness of the testimony of the witness. Faithful performance by you of your duties as jurors is vital to the administration of justice. You should perform your duties without prejudice or fear, and solely from a fair and impartial consideration of the whole case. Instruction number 2. You must not assume as true any fact solely because it is included in or suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. From time to time, the attorneys may make objections. They have a right to do so and are only doing their duty as they see it. You should draw no inference from the fact that an objection has been made. If the court sustains an objection to a question, you will disregard the entire question, and you should not speculate as to what the answer of the witness might have been. The same applies to exhibits offered but excluded from the evidence after an objection has been sustained. You will also disregard any answer or other matter the court directs you not to consider, and anything which the court orders stricken from the record. The opening statements of attorneys are not evidence. Also, you must not consider as evidence any statement or remark or argument by any of the attorneys addressed to another attorney or to the court. However, the attorneys may enter into agreements or stipulation of facts. These agreements and stipulations become part of the evidence and are to be considered by you as such. The parties have asked that the witnesses be excluded during the trial, and I will leave it to the attorneys to make sure that your witnesses are not in the courtroom. Have you done so?
Yes, Your Honor.
So we are ready to proceed with the opening statement of the state? You may proceed.